Hello class, this is Emergency Care and Transportation of the Sick and Injured, Chapter 3, Medical, Legal, and Ethical Issues. In this chapter, after completing this chapter and the related coursework, you will have an understanding of the ethical responsibilities and medical legal directives and guidelines pertinent to the EMT. The EMT approach to patient care relating to confidentiality, consent to treat, refusal of care, and advanced directives are explained in this chapter. We will also be discussing organ donor systems and policies, evidence preservation, and end-of-life issues as well. A basic principle of emergency care is to do no further harm. A healthcare provider usually avoids legal exposure if he or she acts first in good faith and then secondly according to appropriate standard of care. Emergency medical care or immediate care or treatment is often provided by an EMT. EMT is the first link in the chain of pre-hospital care. Providing competent emergency medical care that conforms with the standard of care taught to you will help you avoid both civil and criminal actions. Even when emergency medical care is properly rendered, there are times when you may be sued by a patient seeking monetary compensation. The first thing that's really important to understand is that consent is permission to render care and must be obtained from the patient. A person must give consent for treatment. If a patient is conscious and rational and capable of making informed decisions, he or she has the legal right to refuse care. The foundation of consent is decision-making capacity. First, the patient needs to and can understand the process process information provided to them, which aids them in making a proper decision on their own. And then secondly, the foundation of consent is based on whether or not the patient can make an informed choice regarding medical care. Patient autonomy is the patient's right to make decisions about his or her health. In determining a patient's decision-making capacity, consider these factors. Is the patient's intellectual capacity impaired by mental limitation or dementia? Is the patient of legal age, which is 18 years of age in most states? Is the patient impaired by alcohol, drugs, serious injury, or illness? Does the patient appear to be experiencing significant pain? Does the patient have significant injury that could distract him or her from a more serious injury? Are there any apparent hearing or visual problems? Is there a language barrier? Does the patient appear to understand what you're saying? Does the patient ask rational questions that demonstrate an understanding of the information you're trying to share? Expressed consent means that the patient acknowledges that he or she wants you to provide care or transport. To be valid, the patient must provide informed consent, which means that you have explained the treatment being offered along with potential risks, benefits, and alternatives, as well as the potential consequences of refusing treatment. Informed consent is valid if given orally. Always document when a patient provides informed consent or have someone witness the patient's consent. We discussed express consent. Now let's talk about implied consent. Implied consent applies to patients who are either unconscious or are unable to make a rational, informed decision about their care. Implied consent applies only when a serious medical condition exists and should never be used unless there is a threat to life or limb. The principle of implied consent is known as the emergency doctrine. Sometimes what represents a quote-unquote serious threat is unclear, and it may become a legal question. So it is a good idea to get consent from a spouse or relative before treating a patient based on implied consent. Now let's discuss involuntary consent. This applies to patients who are mentally ill, in a behavioral or psychological crisis, or developmentally delayed in some capacity. You must obtain consent from the guardian or conservator. It is not always possible to obtain such consent, so understand your local provisions. For example, many states have protective custody statutes that allow such a person to be taken under law enforcement authority to a medical facility. Now let's discuss consent in relation to minors. The parent or legal guardian usually gives consent for a minor. In every state, when a parent cannot be reached to provide consent, healthcare providers are allowed to give emergency care to a child. In some states, a minor can give consent. Whether a minor can give consent depends on age and maturity. Confusion surrounds the issue of emancipated minors, however. And an emancipated minor is a person who is under the legal age in a given state, but because of other circumstances is legally considered to be an adult. Many states consider minors to be emancipated if they are married, if they are members of the armed services, or if they are parents. Teachers and school officials may act in place of parents in loco parentis and provide consent for treatment to injuries that occur in a school or camp setting. If a true emergency exists and no consent is available, the consent to treat the minor is implied just as with an adult. Never withhold life-saving care for a minor because a person authorized to provide consent is not available. So just to remind you, again, if a true emergency exists and no consent is available, you want to treat the patient if they're a minor because consent is therefore implied. Now let's discuss forcible restraint. Sometimes forcible restraint is necessary with a patient who is in need of medical treatment and transportation but is combative and presents a significant risk of danger to themselves or others. Forcible restraint is legally permissible. You must consult medical control for authorization, and in some states, only a law enforcement officer may forcibly restrain an individual. Make sure you know your local laws about forcible restraint, because restraint without legal authority exposes you to potential civil and criminal penalties. So again, make sure you know the local laws about forcible restraint. And if that restraint is utilized, it is essential to protect the patient's airway and monitor the patient's respiratory status to avoid asphyxia, aspiration, or any other potential complications. Let's discuss now the right to refuse treatment. Adults who are conscious, alert, and appear to have decision-making capacity have the right to refuse treatment even if the result is death or serious injury. They can also withdraw from treatment at any time, even if the result is death or serious injury. Such patients present the EMT with a dilemma. Should you provide care against their will, or should you leave them alone? Calls involving refusal of treatment are commonly litigated in EMS and require you to proceed very cautiously. You must be familiar with local policies regarding refusal of care. Involve online medical control and document this consultation. It is extremely important that you document everything, but anytime you're involved in a situation where there is a right to refuse treatment and the ramifications are very serious, you must double check and make sure that your documentation is extremely thorough. If a patient, parent, or caregiver's decision to accept or refuse treatment should be based on information that you provide, therefore, it is important that you communicate that your assessment of what might be wrong with the patient is conveyed. You must also provide a description of the treatment that you feel is necessary, any possible risks of treatment, the availability of alternative treatments, and the possible consequences of refusing treatment. All of this information should be included in the patient care report. When treatment is refused, you must assess the patient's ability to make an informed decision. So ask and repeat questions. Assess the patient's answers. Observe the patient's behavior. If the patient appears confused or delusional, you cannot assume that the decision to refuse is an informed refusal. Patients who have attempted suicide or conveyed suicidal intent should not be regarded as having normal mental capacity. When in doubt, providing treatment is much more defensible position than failing to treat a patient. Do not endanger yourself to provide such care, however, but do use the assistance of law enforcement to ensure your own safety if necessary. Before leaving the scene where a patient, parent, or caregiver has refused care, you should again encourage the patient, parent, or caregiver to permit treatment and to call for the ambulance if he or she has a change of mind in his or her condition and/or his or her condition worsens. Make sure to advise the patient, parent, or caregiver to contact his or her physician as soon as possible. Ask the patient, parent, or caregiver to sign a refusal of treatment form. That is extremely important. A witness should be present, and make sure to thoroughly document all refusals. Okay, class, now we're going to discuss confidentiality. In terms of confidentiality, all information should remain confidential between you and the patient. In most states, records may be released only if the patient signs a release, if there is a legal subpoena that's presented, or if the records are needed by billing personnel. Confidential information includes patient history, assessment findings, and treatment provided. If you inappropriately release information, you may be liable for breach of confidentiality, which is the disclosure of information without proper authorization. Now we'll talk about HIPAA, which is the Health Insurance Portability and Accountability Act of 1996, again commonly known as HIPAA. HIPAA contains a section on patient privacy that strengthens privacy laws. HIPAA safeguards patient confidentiality. And HIPAA provides guidance on which types of information are protected, the responsibility of healthcare providers regarding that protection, and penalties for breaching that protection. HIPAA considers all patient information that you obtain in the course of providing medical treatment to a patient to be protected health information. That sometimes is referred to as PHI. Again, that is protected health information. And PHI includes medical information, and PHI also includes any information that can be used to identify the patient. There are certain situations when you may be legally mandated to report your findings, such as in the case of child abuse or if you receive a subpoena. Only the minimum amount of information necessary should be released. Failure to abide by the provisions of HIPAA laws can result in civil and/or criminal action against you and your response agency. So not only can your response agency be held liable, but you can also personally be held liable. Now let's talk about advance directives. Occasionally, you and your partner may respond to a call where a patient is dying from an illness. When you arrive at the scene, family members may not want you to resuscitate the patient. A DNR order, also known as a do not attempt resuscitation or a do not resuscitate order, gives permission not to resuscitate. Do not resuscitate does not mean do not treat. Even in the presence of a DNR order, you are still obligated to provide supportive measures such as oxygen, pain relief, and comfort to a patient who is not in cardiac arrest whenever possible. Each ambulance service should have a protocol to follow in these circumstances, so make sure you're familiar with what your particular protocols are. Other names for advance directives are living wills or healthcare directives. To be valid, DNR orders must meet the following requirements. There must be a clear statement of the patient's medical problem or problems, a signature of the patient or their legal guardian, signature of one or more physicians or other licensed healthcare providers, and DNR orders with expiration dates must be dated in the preceding 12 months to be validated. In this slide is demonstrated a figure that displays an example of a wallet-sized DNR order. This is one type of DNR order that you may see in the field. So this again is an example of a wallet-sized DNR order. Now you may encounter physician orders for life-sustaining treatment, which is also known by the acronym POLST, and again that stands for Physician Orders for Life-Sustaining Treatment, and medical orders for life-sustaining treatment, also known as MOLST, and that is medical orders for life-sustaining treatment. And either of those forms may be encountered by you when caring for patients with terminal illnesses. These medical orders explicitly describe acceptable interventions for the patient. Such orders must be signed by an authorized medical provider to be valid. And if you encounter these documents, you need to contact medical control for guidance. Some patients may have named surrogates to make decisions for them when they can no longer make their own. These are also known as durable powers of attorney for health care and are also known as healthcare proxies. Because of the growing number of hospice home health programs, you may be faced with this type of situation fairly often. If you're presented with an advance directive, you should never become annoyed with family members. The patients and their families should be treated with the utmost respect and empathy. Now, we discussed about physicians determining the cause of death, But there are presumptive signs of death, and these include unresponsiveness to painful stimuli, lack of a carotid pulse or heartbeat, absence of breath sounds or chest rise and fall, and no deep tendon or corneal reflexes. Other presumptive signs of death include absence of pupillary reactivity, which is absence of eye movement and or responsiveness of the pupils in the eyes, no systolic blood pressure, profound cyanosis, and lowered or decreased body temperature. Definitive signs of death are obvious mortal damage, such as decapitation. There also is dependent lividity, which refers to blood settling to the lowest points of the body due to gravity, causing discoloration of the skin. So after death, the blood will pool the lowest points of the body in relation to gravity, and that causes this discoloration of the skin. Other definitive signs of death include rigor mortis, which is the stiffening of body muscles caused by chemical changes within muscle tissue, and that typically occurs between 2 to 12 hours after death. And putrefaction, which is obvious decomposition of body tissues, which, depending on temperature conditions, occurs between 40 to 96 hours after death. Involvement of a medical examiner depends on the nature and scene of the death. In most cases, the medical examiner, also known as the acronym ME, or the coroner in some states, must be notified in the following cases. A patient who is DOA, which is dead on arrival. Sometimes it is called dead on scene, which is also known by the acronym DOS. Death without previous medical care, or when the physician is unable to state the cause of death. Suicide, which is self-destruction. Violent death. Poisoning, known or suspected. And the examiner is also notified in cases of death from accidents, suspicion of a criminal act, and infant and child deaths. You should make every attempt to limit your disturbance of any scene involving a death. If emergency medical care has been initiated, make sure to keep thorough notes of what was done or found. Now, there are special situations involving death or near death, and one of those is organ donors. Organ donors have expressed a wish to donate their organs. This consent is evidenced by information on a donor card or a driver's license. Treat potential organ donors the same as any other patient. Your priority is to save the patient's life, and remember that these organs that they wish to donate need ample supply of oxygen. Here's an example of an organ tissue or donor card. Sometimes people who no longer drive or who just don't drive might have an organ tissue donor card such as this in lieu of an organ donor indication on their state identification card or driver's license. Now, with medical identification insignia, you can also have the indication for organ donation and other specific medical circumstances. And with medical identification insignia, you might notice a bracelet, necklace, keychain, or a card indicating a DNR order, specific allergies, or presence of a chronic disease such as diabetes, epilepsy, or some other serious chronic medical condition. This is helpful in patient assessment and treatment, and some patients wear medical bracelets with a USB flash drive. This is often stored as a PDF file that can be read on most computers. So it's not only for treatment and assessment, it can also indicate their wishes in terms of their organs as well. Here's an example of a medical ID bracelet. In this specific case, it shows a do not resuscitate order. So this is one example of medical jewelry or medical identification jewelry that you might encounter. The next thing we're going to discuss is scope of practice. Scope of practice outlines the care that you're able to provide. This is usually defined by state law. The medical director further defines and sometimes refines the scope of practice by developing specific protocols and standing orders. Carrying out procedures outside of the scope of practice may be considered negligence and also a criminal offense, and are often considered to be practicing medicine without a license. Do not confuse scope of practice with standards of care, which are what a reasonable EMT in a similar situation would do. We're going to discuss standards of care now, and standards of care refers to the manner in which you must act or behave, and that is called the standard of care. The law requires you to act or behave toward other individuals in a definite, definable way, regardless of the activity involved. Generally speaking, you must be concerned about the safety and welfare of others when your behavior or activities can potentially cause others injury or harm. Standards of care are established in many ways. Standards are imposed by local custom, and this means how a reasonably prudent person with similar training and experience would act under similar circumstances with similar equipment and in the same or similar place. You also have standards imposed by law. These are standards of emergency medical care, and they may be imposed by statutes, ordinances, administrative regulation, or case law. Be familiar with the particular legal standards in your state. Professional or institutional standards are recommendations published by organizations and societies that are involved in emergency medical care. Specific rules and procedures of the EMS service, ambulance service, or organization to which you are attached. And as an example of a professional standard is the American Heart Association's standards for BLS, basic life support, and CPR, cardiopulmonary resuscitation. Standards may also be imposed by textbooks. Most textbooks follow the standards established by the National Highway Traffic and Safety Administration, NHTSA. These textbooks are often recognized as contributing to the standard of care that is followed by EMTs. Local protocols or state standards may differ, but the EMT is always bound to follow local protocols. There are also standards imposed by states. One of these is the Medical Practices Act. In some states, the EMT is exempt from the license requirements or licensure requirements of the Medical Practices Act because an EMT is regarded as a non-medical professional. You also have certification and licensure. Certification is the process by which an individual, institution, or program is evaluated and recognized as meeting predetermined standards to ensure safe and ethical care. Licensure is the process by which a competent authority, usually the state, grants permission to practice a job, trade, or profession. And then you have credentialing. And this is an established process to determine the qualifications necessary to be allowed to practice a particular profession or to function as an organization. Now we're going to discuss duty to act. Duty to act is an individual's responsibility to provide patient care. Responsibility comes from either statute or function. A bystander is under no obligation to assist a stranger in distress, therefore there is no duty to act. Once your ambulance responds to a call or treatment is begun, you then have a legal duty to act. In most cases, if you are off duty and come upon a crash, you are not legally obligated to stop and assist patients. There may be some circumstances where this is not true, and you should be familiar with the laws and policies that apply in your service area. If you choose to intervene while off duty, you must continue to provide care until an equal or higher medical authority assumes care. Now, negligence is the failure to provide the same care that a person with similar training would provide in the same or similar situation. All four of the following factors must be present for the legal doctrine of negligence to apply and for a plaintiff to prevail in a lawsuit against an EMS service or provider. Duty is the obligation to provide care. Breach of duty means the EMT does not act within an expected and reasonable standard of care. Damages means a patient is physically or psychologically harmed in some noticeable way. And causation, which is a cause and effect relationship between breach of duty and the damages suffered by the patient. Negligence falls under the general category in law known as torts. Torts are civil wrongs, for example, defamation of character and invasion of privacy. Those are two examples of civil wrongs. With regards to abandonment, abandonment is the unilateral termination of care by the EMT without the patient's consent and without making any provisions for care to be continued by a medical professional who is competent to provide care for the patient. Once care is started, you have assumed a duty that must not stop until an equally competent EMS provider assumes responsibility. Failure to perform that duty is a serious legal and ethical matter and can result in civil action against you. Abandonment may take place at the scene or in the emergency department where you are dropping off your patient. It is therefore always a good idea for you to obtain a signature on your patient care record from the person accepting transfer of care for the patient at the hospital. Okay, now we're going to discuss assault, battery, and kidnapping. Assault is unlawfully placing a person in fear of immediate bodily harm. As far as that relates to an EMT, that would include threatening to restrain a patient who does not want to be transported. Battery is unlawfully touching a person. That would include providing emergency care without consent. Kidnapping, seizing, confining, abducting, or carrying away by force could be a situation where a patient is transported against his or her will. A false imprisonment charge is more likely because EMTs are almost always acting in good faith to provide care. And false imprisonment is the unauthorized confinement of a person. Serious legal problems may arise in situations in which a patient has not given consent for treatment or transport. As far as defamation is concerned, defamation is the communication of false information that damages a person's reputation. And it comes in two forms: libel, which is written, and slander, which is spoken. Defamation could arise out of a false statement on a run report, or an inappropriate comment made on social media or during quote-unquote station house conversation, or sharing war stories with friends, relatives, or neighbors. Be sure that your run report and documentation is accurate, relevant, and factual, and communicate information about your patients only to authorized persons. Good Samaritan laws and immunity. Good Samaritan laws are based on the common law principle that when you reasonably help another person, you should not be held liable for errors or omissions that are made in giving care. To be protected by the provisions of Good Samaritan law, several conditions must generally be met. You acted in good faith in rendering care. You rendered care without expectation of compensation. You acted within the scope of your training, and you did not act in a grossly negligent manner. Gross negligence, conduct that constitutes a willful or reckless disregard for duty or standard of care. That is gross negligence. So let me read that one more time. Gross negligence is conduct that constitutes a willful or reckless disregard for duty or standard of care. Another group of laws that grants immunity from liability to official EMS providers, such as EMTs in some circumstances, are Good Samaritan laws, but these laws do not provide immunity when injury or damage is caused by gross negligence or willful misconduct. The laws vary from state to state and sometimes from district to district, so consult your medical director for more information about the law in your area. With records and reports, you should make sure that you compile a complete and accurate record of all incidents involving sick or injured patients. Such a record is an important safeguard against legal complications. The court's perception of records and reports is that if an action or procedure was not recorded on the written report, it was not performed. And it also views that incomplete or untidy reports are evidence of incomplete or inexpert emergency medical care. The National EMS Information System, or NEMSIS, provides the ability to collect, store, and share standardized EMS data throughout the United States. It is used to improve the speed and accuracy of data collection. Special mandatory reporting requirements. Most states have a reporting obligation for certain individuals, ranging from physicians to any person. The following special mandatory reporting requirements may vary from state to state. Abuse of children, older people, or at-risk adults. Injury during commission of a felony. Drug-related injuries. Childbirth. Attempted suicides. Dog bites. Communicable diseases. Assaults. Domestic violence. Sexual assault or rape. Exposures to infectious disease. Transport of patients in restraints, scene of a crime, and the deceased. So make sure you know your reporting obligations for your state. Ethical responsibilities. Now, in addition to legal duties, EMTs have certain ethical responsibilities as healthcare providers. These responsibilities are to themselves, their co-workers, the public, and the patient. Ethics is the philosophy of right and wrong, moral duties, and ideal professional behavior. Morality is the code of conduct affecting character, conduct, and conscience. Bioethics specifically addresses ethical issues that arise in the practice of healthcare. Ethical responsibilities require you to evaluate and apply ethical standards on your own and in the profession. And EMTs will encounter several ethical dilemmas. Such dilemmas will require you to evaluate and apply those ethical standards again on your own and with those of the profession. So, allow rules, laws, and policies to guide your decision making, be honest in your reporting, and keep accurate records. The EMT in court. You can end up in court as either a witness or a defendant. The case could either be civil or criminal. Whenever you're called to testify, or if you're subpoenaed to testify in any court proceeding, you should immediately notify your service director and legal counsel. As a witness, you must remain neutral during your testimony and review the run report before your court appearance so that you confidently remember what is actually recorded and what actually occurred. As a defendant, an attorney is required, and the attorney is generally supplied by your service in a civil suit. Defenses may include statute of limitations, in other words, the time within a case that must be commenced. If that has expired, then it's too late for a case to actually be brought forth in court. Governmental immunity is generally applied to municipalities or other governmental entities. If your service is covered by immunity, it may mean that you cannot be sued at all, or that it would limit the amount of monetary judgment recovered. Contributory negligence is a legal defense that may be raised when the defendant feels the conduct of the plaintiff somehow contributed to injuries or damages sustained by the plaintiff. Now, discovery is part of the legal process, and it is an opportunity for both sides to obtain more information to reach a better understanding of the case overall. There are two types of information gathering: interrogatories, which are written requests or questions, and depositions, which are oral requests or questions. Most cases are settled following the discovery phase during a settlement phase and do not go to trial. For those that go to trial, several types of damages may be awarded. There are compensatory damages that are intended to compensate the plaintiff for injuries that he or she sustained, and there are punitive damages which are intended to deter the defendant from repeating the behavior and are reserved for cases where the defendant has acted intentionally or with a reckless disregard for the safety of the public. These damages are not commonly awarded as negligence cases. In most cases, if a judgment is rendered against you, your service or its insurance carrier will pay a judgment. However, it is worth knowing that any EMT charged with a criminal offense should secure the services of a highly experienced criminal attorney immediately. Okay, class, thank you for your time and attention. Now let's review what we talked about in this chapter. Review question number 1. You arrive at the scene of an older woman complaining of chest pain. In assessing her, she holds her arm out for you to take her blood pressure. This is an example of A. Implied consent, B. Informed consent, C. Expressed consent, or D. Emergency consent. In this case, it's expressed consent, also called actual consent, and it's when the patient authorizes you to provide treatment and transport, either verbally or non-verbally. In this case, by holding out her arm, she knows you need to take blood pressure, and she's expressing her willingness to be treated immediately. Let's look at the other answers and see why they're incorrect. Let's review the question. You arrive at the scene of an older woman complaining of a chest pain. In assessing her, she holds her arm out for you to take her blood pressure. This is an example of implied consent, which is A, and that is incorrect because implied consent is limited to life-threatening emergencies and is appropriate when a person is either unconscious and or delusional, which is not the case here. B, informed consent, which is incorrect because informed consent is when the patient has been told of the specific risks, benefits, and alternative treatments. C, again, the correct answer here is expressed consent, and it's actually known as actual consent. This patient clearly knows what's going on and what needs to be done. And the fourth answer, D, emergency consent, is incorrect because this is not a form of consent. There is no such thing as emergency consent. Okay, review question 2. Which of the following is an example of abandonment? A, an EMT leaves the scene after a competent adult has refused care. B, an EMT transfers care of a patient to an emergency department nurse. C, an AEMT transfers care of a patient to a paramedic. Or D, an AEMT transfers care of a patient to an EMR. So read them carefully, and let's take a look at which is the correct answer. It would be D. Abandonment occurs when a patient care is terminated without the patient's consent or when care is transferred to a provider of lesser training and of level of certification. So let's review the question and the other answers and see why they're wrong. Again, the question is, which of the following is an example of abandonment? In the first answer, A, an EMT leaves the scene after a competent adult has refused care. Well, that's fine because a mentally competent adult has the right to refuse treatment or withdraw from treatment at any time. Answer B, which is an EMT transfers care of a patient to an emergency department nurse. Again, that's perfectly fine because an EMT can transfer care to someone of equal or higher medical authority. C, an AEMT transfers care of a patient to a paramedic. Again, they're transferring care to someone of equal or higher medical authority. But D is considered abandonment because an AEMT transfers care of a patient to an EMR. That's not acceptable. You cannot abandon a scene and a patient to someone with lesser medical training than what you have. That is legally considered abandonment and by definition is abandonment. All right, let's look at the next question. Question 3. The unauthorized confinement of a person is called assault, battery, false imprisonment, or slander. I bet you can figure this one out pretty easily. The answer is C. False imprisonment is defined as the confinement of a person without legal authority or the person's consent. Let's look at the other answers and see why they're incorrect. To review the question, the unauthorized confinement of a person is called A. Assault, That is not the correct answer because assault is unlawfully placing a person in fear of bodily harm. B, battery. That's also incorrect because the definition of battery is touching a person without providing care or without their consent. Well, excuse me, it is touching a person or providing care without their consent. C, false imprisonment. That's the correct answer. False imprisonment is the unauthorized confinement of a person. And D, slander is incorrect because slander is defined as false and damaging information about a person that is communicated by the spoken word. Okay, review question 4. Failure of the EMT to provide the same care as another EMT with the same training is called A, libel, B, slander, C, negligence, or D, abandonment. I'm pretty sure you can get this one right too, so let's take a look. The answer is C. An EMT could be held liable for negligence if he or she fails to provide the same care as another EMT with the same training would provide in the same situation. For example, if an EMT fails to give oxygen to a patient with shortness of breath, which is an intervention that's clearly indicated in perhaps a situation, he or she may be held liable for negligence. Let's look at the other answers and see why they are incorrect. To remind you of the question, failure of the EMT to provide the same care as another EMT with the same training is called A, libel. That is not the correct answer here because libel is making a false statement in a written form that injures a good person's name. B, slander. That's also incorrect here because the definition of slander is verbally making a false statement that injures a good person's name. C, negligence. Again, that's the correct answer because if one EMT cannot provide the same care as another EMT with the same level of training, that is considered negligence. And then D, abandonment. That is not the correct answer here because the definition of abandonment is the abrupt termination of contact with a patient. Okay, review question 5. An 8-year-old boy was struck by a car, is unconscious, and is bleeding from the mouth. A police officer tells you he is unable to contact the child's parents. You should A, continue to treat the child and transport as soon as possible. B, cease all treatment until the child's parents can be contacted. C, continue with treatment only if authorized by medical control. And D, provide airway management only until the parents are contacted. Read these carefully. Recall different forms of consent, and let's take a look and see what the correct answer is here. The answer is A. The rationale is this. The child in this scenario is critically injured and requires immediate treatment and transport. Waiting until his parents are contacted wastes time and increases his chance of a negative outcome. If you're unable to contact a minor's parents or legal guardian, you should proceed with care based on the law of implied consent. Let's look at the other answers and see why they were incorrect. To remind you of the scenario, an 8-year-old boy was struck by a car, is unconscious, and is bleeding from the mouth. A police officer tells you he's unable to contact the child's parents. You should, again we already know A is the correct answer, continue to treat the child and transport as soon as possible. B is given as an option, and it says to cease all treatment until the child's parents can be contacted. Of course, that's incorrect because if there's a true emergency, consent is implied, and by not exercising implied consent, you could be placing the child's life in immediate danger. C, continue with treatment only if authorized by medical control. Well, that's incorrect, obviously, because if a true emergency exists, then consent is implied. and that is written in your written protocols as well. Or D, provide airway management only until the parents are contacted. Again, if a true emergency exists, then consent is implied. You cannot wait on the parents or guardians or caretakers. You need to treat the child for the sake of their lives. Review question 6. An advance directive is a specific set of guidelines that clearly defines the different types of consent. B, a formal list that defines by state law whether a patient has decision-making capacity. C, a written document that specifies the care you should provide if the patient is unable to make decisions. D, a verbal order given to you by a dying patient's family regarding whether treatment should be provided. So let's take a look at the correct answer and remind ourselves what an advance directive is. The answer here is C. An advance directive is a written document signed by the patient and a witness that specifies the medical care that should be provided if the patient loses decision-making capacity, i.e., they are no longer deemed competent. Let's look at the other answers to understand why this is the correct answer, because all of these terms are very important to know. So, an advance directive is, let's look at answer A, a set of specific guidelines that clearly defines different types of consent. That's incorrect, because an advance directive specifies the specific care a patient will receive and does not address any type of consent. B, a formal list that defines by state law whether a patient has decision-making capacity. Now, this one's incorrect because an advance directive document has already determined that a patient was competent to make decisions when the document was created and signed. That's the important thing. When the document was created and signed, they were of sound mind and body. C, an advance directive is, indeed, a written document that specifies the care you should provide if the patient is unable to make decisions. And D is incorrect because D states that an advance directive is a verbal order given to you by a dying patient's family regarding whether treatment should be provided. Well, of course, that's incorrect because the correct definition of an advance directive is that it is a written order that identifies the patient's medical decisions. Question 7. Which of the following patients is competent and can legally refuse EMS care? A, a confused young female who states she is the president. B, a man who is staggering and states that he drank only 3 beers. C, a conscious and alert woman who is in severe pain from a broken leg. Or D, a diabetic patient who has slurred speech and is not aware of the date. So again, which of these patients is competent and can legally refuse EMS care? Well, of course, it's answer C. And that is the patient who is of legal age, 18 in most states, is conscious and alert to person, place, time, and event, likely has decision-making capacity, and can legally refuse EMS care. Most people with a broken leg aren't going to refuse care. However, it is legally possible for them to do so given the circumstances. It must be noted, however, that patients who are confused, possibly intoxicated, or delusional are not capable of making rational decisions. Therefore, you should provide care to them based on the law of implied consent. So let's look at our other patients here one more time. Which of the following patients is competent and can legally refuse EMS care? Let's look at A, a confused young female who states that she is the president. Clearly, you must assess whether this patient's mental condition is impaired, because She obviously is not the President of the United States. So something's going on physiologically, maybe chemically, maybe both, that causes her to have an incorrect perception of who she is and the circumstances of present reality. B, a man who's staggering and states that he drank only 3 beers. You must assess whether this patient's mental condition is impaired. Maybe he did only drink 3 beers. Maybe there is something else medically going on. Maybe he's diabetic and shouldn't drink 3 beers. Or he's on medication and shouldn't drink 3 beers. Or maybe he drank way more than 3 beers. But in any case, you need to assess whether this patient's condition is impaired in some way. C is, of course, the correct answer. This is a conscious and alert woman who's in severe pain from a broken leg. She can legally refuse EMS care, but isn't likely to. And then D, a diabetic patient who has slurred speech and is not aware of the date. This is really important because diabetes can cause rapid change and alter mental states in someone very quickly. So you must assess not only whether their mental condition is impaired, but that their physiological condition might be in severe peril as well. Question 8. You're treating a patient with an apparent emotional crisis. After the patient refuses treatment, you tell him that you will call the police and have him restrained if he does not give you consent. Your actions in this case are an example of assault, battery, negligence, or abandonment. Answer is A. Unlawfully placing a person in fear of immediate bodily harm, i.e. having him restrained without his consent, constitutes assault. Let's look at these other definitions. You are treating a patient with an apparent emotional crisis. After the patient refuses treatment, you tell him you will call the police and have him restrained if he does not give you consent. Your actions in this case are an example of A. Assault. That is the correct answer. You physically threatened him with restraint, and that is not acceptable. B. Battery. That would not be correct here because battery is defined as unlawfully touching a person. This includes giving care without consent. C. Negligence. That's not correct here either because the correct definition of negligence is failure to provide the same care that a person with similar training would provide. And D is abandonment. That is also not correct in this particular case because abandonment is the unilateral termination of care without the patient's consent. Okay, question 9. The EMT has a legal duty to act if he or she is A. Off duty and witnesses a major car accident. B. A volunteer is on duty and is dispatched on a call. C. Is paid for his or her services but is not on duty. Or D. Is out of his or her jurisdiction and sees a man choking. So let's review legal duty to act. Look at these different options and see which one is the correct answer. It is B. The EMT, whether they're paid or volunteer, has a legal duty to act if he or she is on duty and is dispatched on a call regardless of the nature of the call. If the EMT is off duty and or out of his or her jurisdiction, he or she has a moral obligation to act, but not necessarily a legal one. So hopefully they would want to provide help, but they aren't legally bound if they're off duty. Let's look at the other options and see why they're not correct in this particular scenario. Again, the scenario was that the EMT has a legal duty to act if he or she is A. Off duty and witnesses a major car accident. That is not the correct answer because there is a moral obligation to act, but not a legal one. Again, hopefully they would want to help, but legally they're not bound to. B, a volunteer on duty and is dispatched on a call. That is the correct answer. They are on duty and they're dispatched on a call. It doesn't matter if they're on volunteer or paid or unpaid. They are on duty and they're dispatched to a call, so they have a legal duty to act. C, paid for his or her services but is not on duty. Well, whether paid or volunteer, the EMT must be on duty to have a legal obligation to act. And then D, out of his or her jurisdiction and sees a man choking. Again, there is a moral obligation to act, but not a legal one. Certainly in this case, we all hope that that EMT will be compelled to provide aid. Next question. Which of the following statements about records and reports is false? A, legally, if it was not documented, it was not performed. B, a complete, accurate report is an important safeguard against legal problems. C, an incomplete or untidy patient care report is evidence of incomplete or inexpert emergency medical care. Or D, your patient care report does not become part of the patient's hospital record because your treatment was provided outside the hospital. Look at these carefully and let's take a look at the correct answer. So again, which of the following statements about records and reports is false? The answer is D. The statement, quote, your patient care report does not become part of the patient's hospital record because your treatment was provided outside the hospital, end quote, is incorrect. Your patient care report does, in fact, become a permanent part of the patient's hospital record. Let's look at some of these other answers and see why they aren't the correct answer in this particular case. Which of the following statements about records and reports is false? A, legally, if it was not documented, it was not performed. Actually, that's true. According to court of law, if it was not written down, then it was not performed. If there's no record of something happening, there's no legal way for them to prove that it did indeed happen. B would be a complete, accurate report is an important safeguard against legal problems. Well, that's obviously true also, because the most important safeguard against legal problems is a complete, accurate report. I mentioned earlier, document, document, document. Document everything and do it in clear and concise English. That is your best legal protection. C, an incomplete or untidy patient care report is evidence of incomplete or inexpert emergency medical care. Well, that's true because an incomplete or untidy report equals incomplete or inexpert emergency care. That's how it's interpreted in a court of law, which is why I just mentioned that when you do your documentation, do it with careful and accurate English and clear English. And then D, your patient care report does not become part of the patient's hospital record because your treatment was provided outside the hospital. Obviously, this is the correct answer, and that's false because your record of their care does become part of their permanent care record. Well, class, thank you. I enjoyed working with you on Chapter 3. I look forward to future chapters. Thank you again for your time and attention.